Did you know that a contract can be legally formed from the moment you drop a letter in the post? It's called the postal acceptance rule, and it is a fascinating concept in contract law and one of my favourite things about contract law. So let me explain how it works and why it's still relevant today in the age of emails and texts and everything else that's much quicker. So the postal acceptance rule is essentially the idea that you can send a letter in the post and if you have been offered something, then you can accept that offer in a contract, and the acceptance is considered complete from the moment that the letter is properly posted, not when the letter is received. So if you send your acceptance today and the person only gets it 3 days later, the contract has been legally formed as soon as you posted that letter. So you might be wondering, well, why does the law work that way? That doesn't seem hugely logical. So it's all about fairness and practicality. So before modern communication, posting a letter was one of the few ways that you could accept an offer. And the rule helps to avoid uncertainty by making it clear when acceptance takes effect. So if the contract only formed when the letter was received, there'd be more room for disputes, like what if the letter gets delayed or lost in the post? What happens then? And this essentially comes from a really key case of Adams and Linzell from 1818. And in this case, an offer was sent by post and the acceptance was posted back on time, but the offerer had already sold the goods to someone else, claiming that they hadn't received the acceptance yet. And the court ruled in favour of the person accepting the offer. They said that the contract was formed at the moment of the acceptance being posted, not when it arrived. There are some exceptions to this rule though. So because it's not always that simple in law, we know this, and the exceptions include, so if the offer says that acceptance must be received to be valid, then obviously it doesn't apply, or if it's unreasonable to use the post, like if the offer was made over email and requires a quick reply, and then you just reply with the post. And in modern times, when we've got instant communication, this rule is much less common, but it's still important to know, especially for legal exams or understanding historical cases. What do you think? Should the postal acceptance rule still be in existence in the digital age? Let us know in the comments below.